Big legal changes do not always arrive with dramatic announcements. Sometimes they unfold quietly through procedural updates, revised definitions, or new compliance layers that reshape how the law works in practice. That is exactly what is happening across several states right now. While no single headline declares a sweeping nationwide ban, the combined effect of these changes is altering how firearm ownership, purchasing, storage, and transfers function on a day-to-day basis. For many people, the risk is not intentional noncompliance, but assuming the rules still work the way they used to. Colorado offers a clear example of how this approach works. The state is not banning semi-automatic firearms outright, which is why many residents believe little has changed. Existing owners are not being ordered to surrender what they already lawfully possess. There is no new registration requirement for firearms acquired before the cutoff date, and possession rules for those firearms remain unchanged. That reassurance, however, only applies to the past. Starting August 1st, 2026, the process for buying certain firearms changes significantly. Any new purchase of a semi-automatic firearm with a detachable magazine will require a state-issued eligibility card. That card is not automatic. Before applying, an individual must complete a state-approved safety course that includes live fire training, instruction on lawful storage, and education on applicable laws. The course takes time, carries a cost, and must be completed before the application even begins. After that, applicants must pass a background check to receive the card, which expires every 5 years. Even with the card, buyers must still complete the standard federal background check at the point of sale and comply with Colorado's mandatory waiting period. What was once a relatively straightforward transaction can now stretch over weeks. Private transfers are also affected. After the cutoff date, private sales or gifts of covered firearms must go through a licensed dealer. Failing to follow that process can result in criminal penalties that escalate with repeated violations. The state's strategy is not prohibition, but friction, delay, and increased legal exposure for those who rely on outdated assumptions. Washington takes a different path, focusing less on purchasing and more on ongoing responsibility. Beginning January 1st, 2026, storage requirements for semi-automatic firearms become stricter. When a firearm is not under the owner's immediate control, it must be secured with an approved locking device or stored in a safe. While that requirement may sound familiar, the consequences tied to it have changed. If a firearm is stolen and later used in a crime, and the state determines it was not properly secured, the owner may face criminal charges, not just civil liability. This applies even if the owner was not present and did not contribute to the misuse. Washington also requires completion of a state-approved training course before purchasing certain semi-automatic firearms, with time limits on how recent that training must be. In addition, the state's red flag system allows not only law enforcement, but also certain private individuals, such as family members or roommates, to petition for temporary removal of firearms. The result is a legal environment where storage decisions, training timelines, and personal disputes carry increased legal weight. Connecticut illustrates how enforcement priorities can change the real-world impact of laws that have existed for years. The state has required registration of certain semi-automatic firearms since 2013. For a long time, enforcement was inconsistent, leading some owners to believe the issue was settled. That perception is changing in 2026. Connecticut is launching a comprehensive audit of registered firearms, cross-checking registration records against purchase histories and background check data. Because dealers and background check systems created a paper trail at the time of sale, the state already has the information it needs to identify discrepancies. If a firearm should have been registered and was not, possession alone can carry serious penalties, regardless of how long ago the purchase occurred. Storage rules are also tightening, with improper storage treated as a separate offense. Connecticut is not issuing reminders or grace periods. The responsibility rests entirely on the owner to verify compliance and maintain proof. California continues to narrow its already restrictive system by focusing on what licensed dealers may sell. Beginning July 1st, 2026, dealers are prohibited from selling certain semi-automatic pistols that the state believes could be modified to fire automatically without replacing major internal components. The definition is broad, and the authority to determine which models qualify rests with the Attorney General. An official list will be published, and once a model appears on it, dealers may no longer sell it. Owners of listed firearms are not required to surrender them, but options for transfer within the state effectively disappear. In-state sales and transfers are prohibited, leaving only out-of-state transfers through licensed dealers or surrender to law enforcement. Because models can be added to the list without personal notice, owners must actively monitor updates to avoid losing lawful options. Maryland's approach relies on name-based bans rather than feature tests. If a specific make or model appears on the state's banned list, possession becomes illegal regardless of configuration or prior legality. In 2026, that list is expanding to include additional firearms, some of which were sold legally for years. Once the updated list is published, owners have a 90-day window to act. During that period, they may transfer the firearm out of state through a licensed dealer or surrender it. After the window closes, possession becomes a criminal offense. There is no grandfathering for newly added models and no extension for missed deadlines. Because the state does not notify individual owners, awareness and timing are critical. New Jersey uses a standard that can be difficult to predict, substantially identical. The state bans certain firearms by name and extends that ban to firearms deemed substantially identical in design, operation, or appearance. In 2026, the scope of this interpretation is expanding. Firearms previously sold as compliant may be reclassified without any physical modification by the owner. New Jersey does not provide grandfathering for firearms newly added under this standard. Once a firearm is deemed prohibited, possession becomes illegal immediately, with felony-level penalties. Owners cannot rely on how a firearm was marketed or how long it has been owned without issue. Ongoing awareness of state interpretations becomes essential. New York's changes demonstrate how administrative updates can carry criminal consequences. The state has allocated significant funding to enforcement of assault weapon laws, signaling a more active approach to identifying violations. At the same time, New York is transitioning to a new registration system. Firearms registered under the previous system must be re-registered by June 30th. 2026. Missing that deadline means a firearm previously considered lawful is treated as unregistered, and possession alone can result in felony charges. There are no automatic reminders. Past compliance does not transfer without action. The system assumes owners will track and respond to changes on their own. Rhode Island introduces one of the most restrictive changes taking effect in mid-2026. Starting July 1st, the state bans the manufacture, sale, purchase, and transfer of firearms it defines as assault weapons. The definition captures many semi-automatic rifles with detachable magazines, if they have even one listed feature, such as certain stock designs or threaded barrels. Possession carries felony penalties. While the law includes grandfathering for firearms owned before the deadline, the conditions are narrow. Owners may possess these firearms only in specific locations, such as their home or a licensed range, and transportation must be direct and secured. Transfers within the state are prohibited, and even inheritance becomes complicated unless handled through out-of-state channels. Individuals moving into Rhode Island after the deadline cannot bring covered firearms with them, regardless of when they were acquired. Massachusetts sits at the far end of this spectrum. The state S copycat rule allows the Attorney General to classify a firearm as a prohibited copy or duplicate of a banned model based on design and operation, not just external features. Firearms sold for years as compliant may later be deemed unlawful. Enforcement has already occurred under this interpretation, and the law includes mandatory minimum sentences. There is no single deadline or announcement that triggers risk. Instead, risk arises from evolving interpretations and enforcement decisions. Reliance on dealer assurances or outdated guidance does not shield owners from liability. Across all of these states, the pattern is consistent. Few are relying on dramatic confiscation or sweeping bans announced with fanfare. Instead, they are adjusting definitions, procedures, enforcement priorities, and liability standards. The practical effect is a system where compliance is more complex, mistakes are easier to make, and consequences are more severe. For firearm owners, the most effective response is preparation rather than reaction. Maintaining a detailed inventory, verifying registration status where required, staying current with official lists and definitions, and ensuring storage practices meet current standards are all part of responsible ownership under modern regulatory frameworks. Professional legal advice, tailored to specific state law, carries far more weight than assumptions based on past practice. What matters most is recognizing that the legal landscape is no longer static. Laws are being enforced in ways that rely heavily on process, timing, and interpretation. Staying informed is no longer optional. It is part of navigating a system where yesterday, OS compliance does not automatically guarantee today with S safety. Understanding where the lines are drawn and how they can move is often the difference between lawful ownership and unintended exposure.